5 seconds to go. Start. The learned counsel for the appellant submitted that the impugned order passed based on the minutes of order is completely illegal and vitiated by the non-joinder of necessary parties. The learned senior counsel for the first and second respondents and the learned counsel for the state defended the impugned order by submitting that no one has been prejudiced due to the construction of the compound wall. During the earlier hearings, we had repeatedly suggested to the learned senior counsel appearing for the first and second respondents that the only proper course would be to remand the writ petition with a direction to implead persons claiming to be affected by the construction of the compound wall, as it seems to be an admitted position that several persons are likely to be affected by the construction of the compound wall in terms of the orders passed in the writ petition. However, the first and second respondents did not accept the suggestion. Hence, we are called upon to decide this appeal on merits. We have already quoted what the Deputy Superintendent of Police and the Superintendent of Land Records stated in their respective affidavits filed on 14th March 2022. In so many words, both of them stated on oath that the tribals who own and possess various parcels of adjacent lands were likely to be affected by the construction of the compound wall. In fact, in paragraph 9 of his affidavit, the District Superintendent of Land Records, who is the survey officer of the district under the MLR code in categorical terms, stated that if the compound wall is constructed as desired by the petitioners in the writ petition, first and second respondents herein, pieces of lands owned and lawfully possessed by third parties are likely to get landlocked. Now we come to the minutes of the order. According to the latest affidavit of the first and second respondents, several tribals claim to be owners of the lands adjacent to those claimed by the first and second respondents. The minutes of the order refers to the officers' affidavits. Subclause 3rd of clause 6, which we have quoted above, records that the writ petitioners shall ensure that sufficient access is provided for the other owners of the land whose property falls within the confines of the boundary wall in such a manner that their lands do not become landlocked. Even assuming that Advocate Sambhaji was authorized by 9 interveners to sign, the fact remains that several other owners or occupants of the lands likely to be affected by the compound wall were not impleaded as parties to the petition. Without even adverting to the factual aspects brought on record by 2 responsible government officers in their affidavit dated 14th March 2022, the division bench mechanically passed an order in terms of the minutes of the order and disposed of the writ petition. Now we have a scenario where, under police protection, survey work and construction of the compound wall have been carried out by first and second respondents. An illegality has been allowed to be perpetrated under the protection of the police. As noted earlier, even the government counsel did not perform his duty by submitting before the court as an officer of the court about the failure to implead the necessary parties. Now we deal with the concept of minutes of order, which is peculiar only to the Bombay High Court. This court, in the case of Speedways Picture Private Limited and another versus Union of India and another, had an occasion to consider the practice of passing orders in terms of minutes of order. Paragraphs 5 and 6 of the said decision reads thus. Stop.